Federal Flaws, Perceiving the Problem, Segment 5, Treaty Law. As demonstrated in the previous segments of this video, there is no general jurisdiction available to Congress to pass laws within the several states of the Union. Originally, Congress was given subject matter jurisdiction over 18 enumerated powers, which were found in Article 1, Section 8 of the Constitution for the United States of America. One of those powers contained the Necessary and Proper Clause, which gave the Congress broad latitude in how the subject matter jurisdiction can be applied. The 10th Amendment returned most of the powers delegated to Congress back to the states of the Union within the respective borders of each state. Besides the majority of war powers, the real power retained by the federal government was the treaty-making power. Article 2, Section 2 of the Constitution for the United States of America gives the President of the United States of America the power to make treaties with the advice and consent of 2/3 of senators present. The Supremacy Clause in Article 6 of the Constitution for the United States of America makes treaties created by the United States the supreme law of the land. A properly ratified treaty is more powerful than an amendment to a state constitution. The treaty-making power is one of the last vestiges of Hamiltonian federalism left in the Constitution for the United States of America. The Bill of Rights restricts what the treaty-making power can do to the people, but the 10th Amendment offers very little protections to the states against treaties. Almost any power that one of the several states of the Union could exercise in its legislature is available to the federal government under the treaty-making power. Some examples of treaty-based federal powers are the Fish and Wildlife Service, the Endangered Species Act, federal hostage laws, and federal drug laws. The federal government could only acquire these powers by writing a treaty or treaties that specifically gave Congress the power to write laws on these subjects. Without the power of treaty law, the Congress would have had no basis for passing laws within the several states of the Union on these and many other subjects. The Fish and Wildlife Service draws authority from multiple treaties. Explanation for the history and authority of the Fish and Wildlife Service can be found in court cases like United States v. Connors and Alaska Fish and Wildlife v. Dunkel. How treaty law serves as the basis for federal environmental law can be demonstrated by the Migratory Bird Acts of 1913 and 1918. In 1913, the Congress passed the Migratory Bird Act to regulate the hunting of birds. Cases like the United States v. Shawver and United States v. McCulloch struck down the Migratory Bird Act as unconstitutional. A major precedent for striking down the Migratory Bird Act of 1913 was based on the McCready v. Virginia case of 1877. In McCready, the Supreme Court found that the fisheries were under the jurisdictions of the state. Shawver and McCulloch confirmed that birds, like all wildlife, were under the jurisdiction of the states, not the federal government. From the Shawver case, the exclusive title and power to control the taking and ultimate disposition of wild game in this country resides in the state, to be parted with and exercised by the state for the common good of all the people of the state, as in its wisdom may seem best. In 1916, the United States signed the Migratory Bird Treaty with Great Britain regulating wildlife in Canada and the United States. In 1918, Congress passed the Migratory Bird Act of 1918. Now that the federal laws had the backing of a treaty, the courts upheld the federal control of wildlife in cases like State of Missouri v. Holland. In that case, the Supreme Court was very clear that a treaty can take away a power normally reserved to the state when it said, "No doubt, the great body of private relations usually fall within the control of the state, but a treaty may override its power." The authority for the Endangered Species Act comes from treaty law. Federal hostage laws come from treaty power. Federal laws on criminal possession of controlled substances are based on the Single Convention on Narcotics and other treaties. The Food and Drug Administration's authority comes from the Agreement for Unification of Pharmacopoeia Formulas for Potent Drugs, a 1906 treaty. A valid use of treaty-making power, consistent with government by consent, would be to exchange recognition of rights between peoples. Giving Americans rights, like property ownership in Canada and Mexico, in exchange for allowing Canadians and Mexicans the right to own property, is such an example. Taking powers from the states is a throwback to Hamilton's vision of a supreme, unchecked central authority. Concentrating the general lawmaking power of the several states of the Union in the hands of the President and the Senate amplifies the possibility for special interest corruption. This potential for corruption is compounded by the fact that treaties have input from foreign nations, and the federal authorities in Washington, D.C. are dependent on these treaties for authority. Saudi Arabia can have a greater say in women's rights than Californians. The European Union can have more say than New Yorkers on the subject of free speech. The current interpretation of constitutional law allows for the Congress to override a treaty or for the President to remove us from a treaty. Imagine the President rescinding the Endangered Species Act without the consent of Congress. The purpose of this discussion is not to show the flaws of the treaty power, just to demonstrate how the federal government legitimizes its authority. Never mind that the treaty power is used to circumvent federalism and the intent of the 10th Amendment. When the United States grants a concession to a foreign power through a treaty in order to obtain some power generally prohibited to the federal government, the treaty-making power is literally used to sell out the American people. If the treaty is ever used to create a positive law that oppresses the people, the lawful result is violent revolution. So far in this segment, treaty law has been discussed without addressing the differences between treaties, spelled with a capital T, that are associated with the original Constitution for the United States of America, and treaties, spelled with an uncapitalized T, that are associated with the Undergovernment Constitution for the United States of America. This is because the geographic regions where the original Constitution and the Undergovernment Constitution apply are not the same. The next segment will begin to address these and other such differences. The purpose of this segment was to demonstrate how, under both of these constitutions, that the treaty law could be used to transfer power to the central government at the expense of the states.